A Kaduna State High Court on Tuesday refused bail to former Kaduna State Governor El-Rufai and adjourned further proceedings in his trial to the first week of June 2026. According to the presiding judge, Justice Darius Kobo, the adjournment followed arguments from counsel with the court directing that the matter will proceed on a day-to-day basis at the next sitting. El-Rufai, who was rearrested in February, shortly after his release by the Economic and Financial Crimes Commission, EFCC, has since appeared in court several times and denies all the amended corruption charges against him.
Now, despite securing bail in a separate federal high court case, El-Rufai remains in custody. The charges linked to his tenure between 2015 and 2023 include alleged abuse of office, questionable financial transactions, and also controversial project spending. The ruling has drawn reactions from rights lawyers Chidi Odikalu and also activist Omoyele Sowore, who have criticized it as a departure from the process, while the case continues to fuel debate around accountability, judicial independence, and also El-Rufai's claim that the prosecution is politically motivated.
And joining us to discuss the legal and constitutional implication of this ruling, we're now joined by legal practitioner Tor Seroja. Thank you very much, Tor, for joining us this morning.
You're welcome. Good morning.
Good morning. Now, from a legal standpoint, how do we interpret the decision by the Kaduna State High Court to deny bail and adjourn proceedings while the accused remains in ICPC custody? Isn't this a bailable offense or crime?
Well, it's a bailable offense, but let's lay a foundation clearly that bail is at the discretion of the court, and it depends on the circumstances surrounding the application before the court. But if you look at this situation of El-Rufai, you wonder why the court would have tainted that way, because naturally bail is a fundamental thing, just like it is a fundamental thing one, and it's at the discretion of the court. And if you look at the offense in which El-Rufai is charged, the only thing that would have warrant the court not to exercise his discretion judicially or judiciously is if the prosecuting team put cogent evidence to the fact that he will jump bail or interfere with the investigation. And if you look at it, or with the proceedings, and if you look at it carefully, when a matter has been charged to court, it is presumed naturally the end process of every criminal inquiry ends when the matter has been charged to court. Then that thing goes to the court for the court to determine. So if you look at the basis upon which the court is denying him bail, someone may wonder if the court exercises discretion judicially and judiciously, because naturally it's not a bailable offense based on certain conditions, unlike the one that you don't need to make an application for the court to grant that application. So for him to have denied him bail, I think is something we all need to look at, looking at the body language of the judiciary, then also assess the document presented by the prosecuting team. And we should also look at the circumstances in which he was arrested. You should also be aware that this is someone who has left office for more than 2 years, and investigation was undertaken. He did interfere. So if that is the basis, is something we need to be worried about when it comes to the independent mind of the judiciary.
So will you blame him? El-Rufai has said that this is politically motivated, but when you look at the system and what it's playing like, you might want to empathize with him. I'm not too sure. But then when you take note that there are parallel proceedings that are happening across different courts, and of course, he's already been granted bail in other cases, it seems all the agencies are simply waiting outside each other's doors for him to simply come out, and then they grab him and then put him back into custody again. So does this raise concerns about consistency or whether coordination within the judicial system?
No, first of all, let me point one thing clear when it comes to El-Rufai. May God help us so that we will not become the victim of the system we supported to build. If you look at his antecedent, I think it's not far-fetched of what he's passing through now. Then if you look at it again, you see yes, I will agree with the fact that it's politically motivated. And I also agree with the fact that the agency or the agencies after him, they are not coordinated, because there's what we call intelligence sharing. All this information, they will lump it up. And if you look at it carefully, I don't want to dive into the trial, But you see, at the end of it, it will end up like the Dasuki saga, that up to today we've not heard anything out of it. So many of them, many of the anti-corruption cases that are on the folder. So then, if you also look at it carefully, this is where the judiciary need to stand firm when it comes to his procedure, because if his procedure is interpreted within the average mind to be politically motivated, the hope of the nation is really at stake, because we should separate politics from the law or politics from the judiciary. Come to think of it, the judiciary ought to be the checker of the excesses of the law enforcement agency. But in all said and done, I think he's just a victim of the system he encouraged when he was in power. He created and he nurtured. So he's just a victim. And the judiciary now is no longer a victim, but a co-conspirator of political whiz and political whiz in settling scores.
All right, now, the court has ordered an accelerated day-to-day hearing. In your view, does this strengthen the pursuit of justice or raise concerns about the pressure and fairness in a high-profile trial such as this?
If you look at the Administration of Criminal Justice Act and the Administration of Criminal Justice Law of Kaduna State, and which is the one in Kaduna State, the one that the Administration of Criminal Justice Act, which governs federal offenses, proceedings to federal offenses, you'll notice that it is clearly stated that when it comes to criminal issues, when it comes to criminal financial issues, it ought to be a day-to-day affair. As a matter of fact, delay in justice. Delay in criminal proceedings is affirmed to be delay in justice. So let's see if this accelerated hearing can. One thing is for the court to make an order, so it's not something new. It's something that is provided by the court of by the law which governs the proceedings. So let's just see if the ICPC, the EFCC, all the agencies, they have their evidence intact or their fact intact to put in as evidence. Then we will not be surprised also if he's saying day to day. So why move the hearing to 5th June? You ask your question, why that gap? If the information I got is correct, why that gap? You can say, okay, I'm putting it as a rated hearing. Let it start from tomorrow, which is they call their weaknesses and all those stuff. So, but for him to have taken it that far again, you ask yourself, what are they waiting for? Are they still under investigation for keeping in custody? You look at the constitutional provision of the fundamental right provision of the Constitution, whereby bail should be granted. So these are questions, these are issues that cause for questions. Yeah.
And honestly, it's quite concerning. The former governor has called this a malicious overreach. He cited what happened earlier in the year where he was returning from Cairo and in Abuja. There were attempts to arrest him. We all saw the clips. And again, he believes, just like you have said, that there's some undertone and there's some motivation behind this. And many other people have criticized this. The critics like Chidi Odinkalu and Omoyele Sowore have described aspects of this process as a departure from due process. But you've given a legal explanation for, why the court may have done this and, the other side. But where do we then draw the line between what is a legitimate prosecution and what is a perceived judicial overreach?
Okay, where we draw the line is the process itself. The process itself. And the process starts from the gateway. What is the gateway? The point of invitation or arrest. That is where you draw the line. Then the other thing again is you could see. Let me point out something that should be worrisome to Nigeria in this case. Let me point it out. And I think maybe Nigeria did not look at it carefully and holistically. This is someone who went to court, his bail application was not heard. They understand, which ought to be, and he was taken in custody just because he lost his mother. They understand that process was breached and he was released on compassionate ground. That should send a message to the judge handling this matter. If he can be released and he came back again, exactly. I see no reason. I see no reason why the bail application was not held. So the politically motivated, yes, it can be stated so, looking at his position, and he's a bit smart to say that, okay, well, we don't know if he's innocent or not until he's proven guilty, but he has positioned himself in a way whereby whatever step taken currently, it will be inferred to be politically motivated. But just like I said, El-Rufai, though I sympathize with him, and I questioned the processes currently, but El-Rufai should, what is passing through now, should send a message to the current political actors, the power brokers, that a system will not shut or will encourage that is unjust. If it is not dismantled while they are in power, they'll become victim of that system. So El-Rufai is currently a victim of that system currently. So we should not look at his if we look at his antecedent as governor of Kaduna State, you should know all these atrocities he has done. If you also look at his antecedent when he was the FCT minister, where even when a live broadcast was going on, he ordered the demolition while a live broadcast is going on in a known television station in Nigeria then. So it is what it is. But if you look at it carefully, you can easily detect from a very clear point of view that is more of politically motivated process rather than a judicially laid out process you can think of.
Arturo, you've doubled down on that one, but one thing you said from before that I found very interesting was the Dasuki instance, which you compared this to. It was a very dramatic one, and it seems that what's happening here now at El-Rufai is equally as dramatic. But when you compare these two cases, I'm wondering whether it's the same, whether you can say that this is the same legal process or principles being applied differently, and what the effects of these would be on this current case.
Well, basically, there's no same legal scenario, but there are same legal proceedings. But we can also the fact that there are same political motivated processes. So that is something we can detect. So the actor on this regard now, you look at the judge in question. You know, Dasuki's own, why I link it to Dasuki's own, that's how it was blown. It was reported all the media. As a matter of fact, Nigeria was made to understand that conviction is just 2 days away from the day it was arraigned. But up till this point now, I think, Dan, we are talking about 9 years down the line. We've not heard if there was a conviction or if there was an acquittal or if a newly prosecution was entered. The matter just fizzled out based on politically alignment, whatever we can think of. So now bringing it to El-Rufai's own, the legal proceedings, yes. I will say that for Dasuki's own, he was granted bail, but the DSS and Buhari, who wanted to settle score as a result of what happened during when he was when coup d'etat took over his government, refused to grant him bail. But this one, it was clearly stated that the judiciary seems not to be independent in this one. One thing is for the judiciary to do their job, then the society will not look if the harm is being done. So I won't say legally it's the same processes, but politically it's the same processes when on this particular regard. But it's a shame, and it's something that we should not accommodate.
I mean, just to highlight that there are two cases going on concurrently. The Federal High Court, the State High Court, one has granted him bail, one hasn't, which is why he's still in detention. And I know that there would be a cause for concern, and many will wonder, why is it that if the two of them, if one person grants bail and the other doesn't, which should take precedence over the other? And also, what legal remedies lie, or what legal remedies are available to him pending the hearing of the bail application? Can he maybe approach a higher court? What are the next options for him?
Okay, this is where it comes dicey when it comes to advocacy, particularly the issue of his counsel now. Now, I believe that part of the issue that the prosecution team will canvass for the court is that you should undertake not to commit several offenses or commit any offenses. You understand? He has no pending proceedings. Then they will not ask, at the time this case was filed, as he be said to have committed the said offenses, he was granted bail. That is one. And I believe the learned judge would have lied on his learned brother to have granted him bail on the terms in which that court has granted him bail. Then if you now look at it holistically, let's look at it holistically from the proceedings, as you stated clearly, is the facts still remain that the options available for him is to approach the Court of Appeal for his bail. Because if the High Court deny him that bail, it's to approach the Court of Appeal. But there are also proceedings whereby he can still bring the bail application again. And I've done that I've done that before, even the Federal High Court, where a bail was denied. On the next hearing, I filed another bail application, and it was granted by that same judge. That is applicable due to a change in circumstances. So that can be done. And we should not also forget that, primaries are around the corner, conventions are there. He was not at his newly loved party now, convention, purported convention. So these are tactics to see how 2027 will play out. But one thing I know for sure, that what the powers are doing is giving El-Rufai voice. And I'll tell you clearly, El-Rufai does not have the voice he's having now, even while he was a governor. He's not having the voice. But because of what is going on now, he has gotten that voice and sympathy even across board. So he's one of the, should I use the word, not liked public office holder when he was in power. But now with what is going on now, he's getting that sympathy and he's getting that love from the masses. So it's for the courts to approach the Court of Appeal for the bail.
Okay.
All right, so what precedent could this set for politically exposed persons who are facing corruption trials in Nigeria?
The precedent is that they should start dismantling a system that is unjust, a system that is alien to process, a system that is alien to proceedings. They should start dismantling the state. They should start looking at a stronghold of institution. I'll give you an example. Here in the UK, I go to court. I witness court proceedings. You see a clear distinction between the judicial arm of government and every other institution. You will see the clear distinction, but in Nigeria, it's not the case. In Nigeria, you see the prosecutor is a staff of the courts, and you see a judge, particularly the lower court, you say, let me speak to my prosecutor, let me consult with my prosecutor, not let's consult. The prosecutor is seen as part and parcel of the court, but they are all ministers in the temple of justice, and they ought to stand fairly before the judge, who is an unbiased. So it's for them to look at it. If El-Rufai, who was once I think it was one of the prominent figures in Buhari's administration, if he's undergoing this now, and the judiciary has been so coerced or reduced to the fact that they cannot exercise their discretion in line with their oath of office, they should know that they are all going to be victims of this system they are creating. Well, and that is something we should be sure of.
Tor, thank you for joining us this morning. You've said that El-Rufai is, in not the exact words, but basically you saying that he's suffering maybe from a system he helped create. You know, and,
yes.
And I mean, our politicians are watching, the Nigerians are watching, want to see what the outcome of this case is. I think one very suspicious thing with this particular case is how they have in some way tried to limit media access to the courts. Typically, journalists are allowed in, but more than once, our journalists have tried to get into the court and they haven't been allowed in. I'm hoping that, that's something that has been rectified, and so that we're not having to get hearsay reports from the different sides, because the truth is everyone will interpret it as they deem fit.
Olive,
so we want to hear everything live.
Olive, I wanted to say something. Talk about poetic justice. That's all. Interesting.
So thank you for your time with us this morning. We look forward to speaking with you again.
You're welcome.
All right. Quite an interesting conversation there. Keep the comments coming. I'll take a few comments on YouTube and then I'll share with you what's coming up next. Media Judges says this administration will stylishly deal with El-Rufai small. Mokunye Chukwuemeka says El-Rufai is reaping what he sowed. And Victor Kebata says, will those in power now learn from El-Rufai's experience that power is transient, karma is real, and we reap what we sow?